Welcome to Real World Copyright for Lawyers. This session will cover the basics of copyright as you might encounter it in your legal practice. The basics of copyright are simple. Copyright protects certain content for a limited term with specific exceptions. So there's some content, there's a limited term, and then there are some exceptions to the protection. The original formation of copyright in the United States comes from the Constitution, and as such it is federal law. There are adjacent state statutes, but the basis of this conversation will be about federal law. In general, we've seen quite a few technological revolutions, whether photography, photocopying, the fax machine, the internet, and now generative AI. All of these have been dealt with in the past by analogizing to past practices and saying, is this similar or is this different from what we've done in the past in terms of copyright and how we've addressed the problem? So when you start to think about a new problem, one of the ways that copyright handles it is trying to analogize to the challenges of the past. International aspects are beyond the scope of today. There are treaties, there are whole different regimes in other countries, and while fascinating, they would take too long to cover. Let's start with this example. Let's say that you created the map on the left, and you recently saw the map on the right. You might be angry. You might say, hey, they took from me. That's copying. Well, one of the questions about this is, what is protectable on the left, and was what's protectable on the left taken and used in what's on the right? So the rest of this conversation is going to talk about the relationship between these two works and whether there's what is protectable and what is not. So let's start with what is copyrightable. This is defined in 17 U.S.C. 102. And it includes some things that you might think of naturally: literary works, books, poems, musical works. So that would be the music, but it also might be the accompanying lyrics. Dramatic works, which is sort of the flip side. It's the spoken word, but also any music that goes with the spoken word. We have choreography, then we have images, graphics, and sculpture, motion pictures, audio recordings, which are different from music, right? Because music is written on the page in general, and the sound recording is the performance of that and the fixation of that. And then architectural works. In addition to all of these, another area of protection is compilations and derivative works of the above. So a compilation might be a book of poems, or it might be a book of public domain pictures. We'll talk more about protection, but if something's in the public domain, it's no longer protected by copyright, but your compilation might be. Or if you created a movie based on a public domain painting, then that movie will be protectable even though the underlying painting might be in the public domain. Here's some things that are not copyrightable, and this is where often people get confused. Cooking recipes. Well, a cooking recipe is just a series of facts in most cases, and therefore if you say it uses this quantity of this and that quantity of that, then that is a fact and that's not protectable. Another area where this is relevant is in fashion designs. While they might be unique or distinctive in some other ways, they're not copyrightable. Your friends may ask you about copywriting their band name, but really that's trademark. Trademark is often shorter things and images that you use in trade to represent quality, as opposed to content that's copyrightable. But things can be both copyrightable and trademark, such as Mickey Mouse. genetic code and other useful articles are really belong in the domain of patent law. They may have an aspect of aesthetic quality, of sculptural quality, and there's some great cases on the topic, but in general, we're going to leave that stuff to patent. Like a cooking recipe, if you have an idea or a concept or something that's quite broad and general, then that's not going to be protected necessarily. So what we need here is an actual expression that is fixed for it to be protectable. And in another area, most federal documents are not protected because of a section of the copyright law. That is not the same for state materials. So some state statutes and state cases, people do claim ownership of, let's say, the synopses and some of the notes. Okay, so we've talked about what's copyrightable, and in the case of that map, the artistic quality of it, let's look at that again. The artistic quality, the way the colors that were chosen. If I wanted to exactly copy the work on the left, that would be a problem. However, if you look at the work on the right, it's not copying it exactly. There are stylistic similarities. There is also stylistic differences. You might say, well, the roads in this one have two sides on the right, whereas they're just lines on the left. You might say that this is mostly outlines on the right, whereas those are solid color fields for most of the areas on the left. So one of the questions that we get to now is what rights do you have? Even if we are clear that the work on the left is protected, what rights do we have regarding the one on the right? So the first thing is reproduction. You can't reproduce the work on the left and sell it as your own. Okay, that seems pretty clear. I also couldn't base a play or a painting on the work on the left without licensing it or some other things that we'll talk about later. So a derivative work is something that comes from the original and that is very specifically tied to that original, rather than being sort of a generic trope. If I write a detective novel and then you write a detective novel, well, that's okay because you're not necessarily creating a derivative work of my detective novel. You're just writing a derivative work of something else, of the general idea of detective novels. Also, you can't distribute copies or sell content to the public without the permission of the owner. There are some details. So the way that libraries do this, for example, is they purchase copies and then they distribute those copies. And that's permitted because they purchased the original copy, and then there's another doctrine that kicks in that lets them loan it. And then we have public performance rights and also public display rights. And these are a little more esoteric and are fascinating areas to explore, but in general, they have more complicated facets to them. And finally, there's a world of performing music via digital audio, but we're going to leave that aside. All of this is codified in 17 USC 106, and there are a slew of annotations in the annotated code that cover this, each of these in great detail. One question that people often have is, well, is copyright the same as plagiarism, or is it different? And I would say I'm using this image from a site that no longer exists, but copyright would be photocopying a whole journal and giving it to students while crediting the authors. We're going to get to why that's acceptable because of a defense called fair use. But that is implicit, it invokes copyright issues, right? But it doesn't invoke plagiarism issues because it gives credit to the authors. Okay. On the other hand, plagiarism is if I take a collection of poems from the 1700s and I don't cite the author. Now, there's not a copyright issue because those works are in the public domain, but there is a plagiarism issue because I've removed the attribution and I'm potentially asserting that I wrote them, which is deeply problematic because that's misrepresenting the authorship of the work. Now, these two do overlap in the case of somebody, for example, writing a textbook or writing a paper, paraphrasing or copying a portion of it, and then not crediting the author, because that's really both a copyright issue, assuming that the work is still protected by copyright, and it's also a plagiarism issue because the author was not cited and attribution was not given. So this is a handy way to think about how they're similar and how they're different. Now we get to what's infringement. So copyright infringement is when you feel that something's been taken from you as a creator, or if someone sues you, someone feels that you took from them. So if someone violates one of those rights, then you have to prove first that you own the copyright in the work. So that is that you either registered it or that you created it. We'll talk more about registration later, but it's not required that you register a work to prove that you own it. But you also have to make sure that you didn't do it for your employer and that actually someone else owns the work. Because if someone else owns the work, then they're the people or they're the party that can bring the suit, not you, in most cases. And then you have to prove that they copied. So either there has to be substantial similarity between yours and theirs and access to the original, if possible, but also someone can create a work, an identical work independently, and have both of them can have copyright. So just because something is similar to yours, if two poets on opposite sides of the world both wrote the same poem, it is possible for them both to be protected, and one cannot disenfranchise the other. So if we go back to the original painting that we were looking at before, we can see that there is some similarity. Like if we look at the text, the writing on above, Harlem is written in a certain way. That's maybe relevant. We can look at the building structures, the way they're depicted. Now, one of them tends to look a little bit more two-dimensional, a little more childlike, maybe, creating and evoking a sense of wonder, but and charm. The other one looks like it's going for a little more detail and maybe a little three-dimensionality. Whether those are substantially similar or whether they're both sort of charmingly depicted buildings, is really open for interpretation. That might be quite a difficult case to make because they're both of the same style, but that style is actually seen in many contexts. In addition, the maps are seen in many contexts, and these both depict the locations of the cities that they are depicting. And they're somewhat different, really, in the choices that they made in terms of the greens and blues that were used and the way, again, the roads and color fields were depicted. So I think there would be a difficulty saying that anybody that creates something like that on the right is infringing on that on the left, even though I do think they evoke similar feelings, but that might not be something that the law wants to protect and lock up, that any city depiction that has these sort of charming structures overlaid on a map of the city is something that we want to grant to one person. Maybe it should be held more broadly. So now we're going to get to a case that's very different. This is a case where a photographer took this picture of the 8 puppies, and then Jeff Koons created a sculpture based on it. And here we see far more similarity. Okay, we see the bench behind, we see the puppies in basically a very similar configuration, down to the sort of the third one over from the left having their legs drop down. And this is a copyright case that Jeff Koons did not win. He argued that it was, a transformative work and that there was some other stuff going on, but really he took from the photo and replicated it in a three-dimensional sculpture, which would be considered a derivative work, which is one of those 106 rights, and that would be copyright infringement. So let's talk about one defense or one way exception to copyright, and that is fair use. So this is all codified in Section 107, and what it is fair use for the purposes such as criticism. Like if you want to critique something, you should be able to quote it. If you want to comment on something, you should be able to refer to the original, because you have to do that to be able to comment on it. News reporting, teaching, including multiple copies for classroom use, scholarship and research. So the purpose, if the reason you're using it is one of these, then in general, it's not an infringement of copyright. Now, there have been some interesting cases involving classroom use, and really this is intended for somebody to not use the same material year after year without licensing it, and more sort of, I want to bring this in and talk about this article. That is clearly fair use. Let's talk now about the four general factors. First of all, this is not an exclusive list of fair uses, it's an inclusive list. Note the word including in this, but also these four factors are not exclusive. So what we're going to look at when determining if something is a fair use, and therefore, even though somebody's 106 rights have been violated, this exception applies, is, well, what is the purpose or character of the use? Am I showing a Disney movie for the entertainment of a large group of people? Or am I recreating, let's say, a law review article to show the court or to distribute in class on the spur of the moment? So one would be about a commercial nature. For example, am I charging people to come see the movie? Or does it have an educational aspect to it, such as the distribution of the article? So that's the nature of the use. That focuses on how the second person used the creation of the first person. The next one is the nature of the copyrighted work. This goes to what is the thing? Not how is it used, but what is the thing? Is it an article? So for example, I could show a Disney movie or a clip of one that is intended to be educational in a class. Now, the use is educational, but the work was created as entertainment. The nature of the work in another case might be, it's hard to imagine using a law review article for a major motion picture that is purely meant for entertainment. But the nature of the copyrighted work in the case of the law review article would be educational, and the nature of the Disney clip would be commercial. So you take those two, you look at them, and especially when you see that something is intended to be entertainment and it is being used as entertainment, that's the most problematic, because there's not like a social benefit to that use that this section really is intended to get at. However, if I'm using a scholarly work in a scholarly context, then that's far more likely to fall under fair use. Now, another aspect of this is how much did I take? Did I take more than I needed to? For example, if I was teaching a law school class and I showed the entire movie My Cousin Vinny, that is taking far too much of the movie. But if I wanted to show just a minute of a courtroom scene to illustrate cross-examination, that might be perfectly acceptable. So thinking about the quantity of the work and also the quality of the work, it's a very complicated concept, and there are quite a few cases on this, but there are cases where taking a little bit is not okay, and there are cases where taking quite a bit is okay. So it's a very fact-based inquiry, as is all of this. And finally, the most complicated factor in some ways is the effect of the use on the potential market. So that question is, if I am permitted to use this work that you created, am I somehow diminishing the market for your work? Or am I really entering a completely different domain, and therefore nobody who likes my work would really be interested in yours? And if I create a rap version that uses a little bit of your country music song, on one level, they're both music. On the other level, maybe they have completely different audiences and they don't affect each other that much. And again, it's a court-based inquiry. But that's a summary of fair use, and this is a way that you can run through this analysis and casually but thoughtfully say both how is this going to work, but also break it down into these 4 factors and consider how it looks to a jury or to the court. Here are 2 examples I don't want to dwell on, but where there was a discussion about whether the use of the photograph in the poster and whether the use of the photograph and embellishment of it are fair uses or not. So I think we could have a reasonable discussion about whether that poster was a fair use or whether instead the photo should have been licensed. And also in the second one, should the artist who painted over that photo and created a new work, whether they affected the market for the original or whether they were really creating a new market by painting over it. So there's quite a bit to discuss, and almost all of it is factual. So people can have very different opinions, and it ultimately depends on what the court finds. There are some issues we haven't touched on, and I'd just like to briefly mention them. The first one is licensing. I've mentioned a few times, licensing really is contract, but there are many ways to license. There is Creative Commons, which is a type of license. There's giving content away, but also potentially limiting its use. There are questions about if I click I agree, am I really bound by everything in it? So contract law is adjacent to copyright in certain contexts and needs to be considered. Another area is, did you try to license the work? They declined that license and then you used it anyway. And whether that cuts for or against your use of that work. Another one that's exceptionally complicated is the length of copyright. So I haven't talked about that, but based on the Constitution, one aspect of the limited term is that at some point it becomes in the public domain and can be used by everyone, thereby benefiting all of us through the creation of new knowledge and new works. So the length of copyright, whether it's life plus 70 years or in corporate contexts, it can be a little bit different. You should look it up, really, and it's malpractice not to figure out whether some work is or is not in the public domain if you're making a judgment about it. We're not talking about breach of copyright abroad. For example, there's a lot of civil procedure and jurisdictional issues about what law applies that we're not touching on. Copyright registration, you may have been used to seeing a notice of copyright. And while it used to be required, it's no longer required. But notice is beneficial for 2 reasons. One is it tells the other party that's using the work that it is protected. It's telling them who to contact to license it. And also by putting them on notice, it removes something called the innocent infringer defense, which increases your damages if you ever get to that point. And in addition, beyond fair use, there are many exceptions to copyright law, but they're all very narrow, niche exceptions that are not worth going into in this presentation. However, if you're interested, they're all within 17 USC in the 100 series. Now, I want to close this session by talking a little bit about common sense. You can resolve most copyright disputes by writing someone a nice email that says, "Did you know you violated my copyright when you did X?" If your client receives a letter like that, or even receives a nasty cease and desist letter, You can also often resolve the issue by responding with an apology and saying that you'll take the offending picture off the website, or you'll stop using that sound clip, or whatever the case may be. And it really, the foundation of the emails is copyright law, but you don't need to go to copyright law when it can be resolved often in a very informal and far more constructive way. In addition, you can use infringement or fair use as an educational opportunity. So you can write the letter as, I know you might not have realized it, but my use of your photo in my class was an educational use, and I believe it fell under fair use for these various reasons. So don't consider that somebody who's saying that you violated their copyright is necessarily understanding the nuances of the situation or the use of it. So remember, legal remedies are a last resort, especially in this area, not the first resort. And now you know everything you need to know about copyright, and I hope you enjoyed this session and have a great day.